is authorized to declare a recess at any time. Today, the Rules Committee is convening to consider H.R. 77, the Midnight Rules Relief Act. The Midnight Rules Relief Act was considered by the Rules Committee and passed the House before the 118th Congress ended. We're back to finish the job and to set this bill on a glide path directly to President Trump's desk. Previous administrations, both Republican and Democrat, have churned out hundreds of new rules, what we refer to as midnight rules, as the clock winds down on their respective tenures. As a direct result, Congress becomes mired in regulatory malaise. It's an all too familiar occurrence that should be remedied. Now Congress already possesses the power to hold regulatory overreach in check via current law, which is a Congressional Review Act. That said, a Congressional Review Act is limited in scope in that it applies to a single rule. For subsequent rules that are issued, each one requires its own separate resolution. As one can imagine, previous administrations, both Republican and Democrat, have seized upon this and inundated Congress with regulatory blitzes, often to the detriment of the very people we are here to serve, our constituents. The Midnight Rules Relief Act provides a reasonable common sense remedy to this problem that has existed for decades. H.R. 77 provides the legislative branch with a leg up with respect to executive rulemaking, regardless of the administration, by allowing Congress to consider multiple rules in one fell swoop. The result of this is twofold. Congress can keep pace with the issuance of midnight rules, and it can also provide a necessary diligent check against the federal bureaucracy. Spurring congressional efficiency and reining in the federal bureaucracy at the same time are causes worthy of bipartisan support. I certainly believe that to be true. Speaking of bipartisan support, I'll note this legislation did receive bipartisan support in December. I do hope that more of our Democrat colleagues will take the opportunity the second time around to join us in passing it. I look forward to the discussion on this legislation, and I yield to Ranking Member Mr. McGovern for any comments he wishes to make.
Well, thank you, Madam Chair. And as you mentioned, today we will consider H.R. 77, the Midnight Rules Relief Act. We met on this bill back in December. Now the stakes are even higher. So let's be very clear. This bill is nothing more than a blatant power grab by House Republicans designed to make it as easy as possible to gut protections for everyday people. And who benefits? You guessed it, billionaires and special interests. Because the thing is, billionaires want no workplace protections. They want no rules against dumping toxic chemicals into our food, water, or air. They want no restrictions on corporate greed. And Republicans are all too happy to help them get their way by dismantling the very agencies that hold them accountable. The goal is to destroy our government and rebuild it to serve the president, his cronies, and the ultra-rich. The Midnight Rules Relief Act is just another tool to speed up that process. And it's right out of the Project 2025 playbook. Remember that? Project 2025 writer, now OMB director, Russell Vought, wrote, and I quote, "To leverage the CRA's power to the maximum extent, Congress and the President should enact the Midnight Rules Relief Act, which would help to ensure that multiple regulatory actions could be packaged and voted on at the same time," end quote. Translation, if Republicans win in November, which they did, they want this bill in place so they can gut regulations immediately, handing even more power over to polluters, scammers, monopolies, and corporate profiteers. And who will pay the price? The American people. The last thing we should do is give Republicans another weapon to dismantle our government. You control the House and you control the Senate. If you want to strip protections from hardworking families, put your mandate pants on and have the courage to vote to roll back protections one by one so that every American knows exactly where each of you stands. And with that, I yield back.
Thank you, Mr. McGovern. Without objection, any prepared statements that our witnesses may have will be included in the record. I welcome our first panel, Representative Klein and Ranking Member Raskin, from the Committee on the Judiciary. I remind witnesses that your full statement may be submitted for the record, and we ask that you summarize your statement in 5 minutes or less. Representative Klein, I welcome your testimony.
Thank you, Madam Chair, members of the committee. H.R. 77, the Midnight Rules Relief Act, is an important piece of legislation that will allow Congress to more effectively and efficiently oversee federal agency rulemaking. Under the Congressional Review Act, known as the CRA, executive agencies must report all promulgated rules to both chambers of Congress. This reporting requirement allows Congress to properly consider federal regulations before they take effect. The CRA gives Congress the ability to pass joint resolutions to prevent these agency rules from taking effect. The CRA's disapproval mechanism is a critical check on federal administrative overreach. However, the CRA requires Congress to consider a single, separate joint resolution for each agency rule it seeks to render unenforceable. This one-by-one approach to joint resolutions under the CRA slows Congress's oversight of agency rulemaking. Its inefficiency is most clear during the midnight rulemaking period of the last year of a president's term, when executive agencies historically issue substantially more regulations. So the problem of midnight rulemaking is most clearly seen by examining the Biden administration's rules that fall within the CRA look-back window. This window includes any rules submitted to Congress from August 16, 2024 to the end of the Biden administration. During that period, the Biden administration finalized a staggering 1,406 rules. By forcing Congress to consider rules but one by one, the CRA limits Congress's ability to review such an onslaught of rulemaking in the twilight hours of a president's term. H.R. 77 would make Congress's oversight of agency regulatory activity during this midnight rulemaking period more efficient. The Midnight Rules Relief Act would allow Congress to introduce joint resolutions covering multiple agency rules during the final year in a president's term, and this change would allow Congress to efficiently respond to the influx in agency regulations during the midnight hours of the president's term. I look forward to answering any questions you may have. Madam Chair, I yield back.
Thank you, Mr. Klein. 2 minutes. Very good. Mr. Raskin, you're recognized.
Thank you, Chairwoman Foxx. The pressure is on. So the purpose of the bill before us is not to give Congress the power to undo midnight rules, because Congress, as you say, Madam Chair, already has that power. For example, right now, House Republicans can try to undo every single rule issued by the Biden administration from August of last year to Inauguration Day. This is a potent power which properly reflects the broader congressional power to legislate and to correct or revise an agency's interpretation of a statute. So what does the bill do? Well, it would allow a majority to roll up lots of midnight regulations, indeed all of them adopted in the final months of the prior administration, together, tie them into a large bunch, and then vote them down in a single jumbo resolution. This tactic would be used to try to get Congress to eliminate all available midnight regs in one fell swoop, forcing every member to vote either to sustain all of the regulations or to vote all of them down. This would allow the 119th Congress, for example, to tie all the 66 relevant Biden regulations from last term into one bundle and move to vaporize them in a single vote. It would undoubtedly take place with precious little debate, but even if there were meaningful debate, the whole process would be deeply flawed, because what's a member to do if he or she strongly approves, say, of overturning 50 of the rules, but strongly opposes overturning 16 of them? Do they let the majority of the bills overtake the minority and vote aye on the whole package, or do they give the smaller group of bills the veto power and vote no? This weird dilemma forces us to ask why we would even force such a choice. The manifest purpose of the bill is to allow House members to hide from the political consequences of voting to repeal rules one by one. It allows our GOP friends to say they were forced to overturn some really good water quality or infant safety regulations because they were so eager to strike down some other big bad regulation in the package. Instead of considering these regs one at a time on their merits, as current law requires, the bill creates the power in Congress to wipe out potentially hundreds of regulations in a single coercive party line vote, or 66 of them in this Congress. When I first heard about this classic inside the Beltway legislative subterfuge, I immediately wanted to get in touch with the gentleman from Arizona, Representative Andy Biggs, because I remembered that he was the proud and very compelling sponsor of H.R. 91, the One Bill, One Subject Transparency Act. This legislation requires each bill or joint resolution to, quote, include no more than one subject, and the subject to be clearly and descriptively expressed in the measure's title. Thus, the Midnight Regulation Kitchen Sink Bill would violate everything Congressman Biggs believes about the legislative process. Members should be voting on one subject only, or one regulation at a time, not a dozen different subjects and a dozen different rules. And the title of the bill should clearly communicate its proper subject. But amazingly, before I could get to Representative Biggs to tell him that we had to get together to stop this monstrosity, I was told by my staff that he was actually the author of the Midnight Rules Relief Act. The lead sponsor of the One Bill, One Subject Transparency Act is now advocating this massive conglomeration of subjects and decisions, a huge legislative stew where poison pills and healthy vegetables are mixed up freely and thrown in together for one deliberately confusing and incomprehensible meal. This approach is exactly what my friends in the Freedom Caucus have complained about for years. The passage of needlessly complex legislation covering way too many topics at once. As Mr. Biggs' press release on One Bill, One Subject stated, too often congressional leaders use must-pass bills as methods for passing other laws that may have failed if considered on their own. Mr. Biggs' traditional solution to this problem has been simple. The One Bill, One Subject Transparency Act, which he fought for last Congress, would require that every bill considered by the House encompass no more than one subject at a time. And if it doesn't, if it goes beyond that, the entire bill becomes void. So I will stand up for the principle I once thought unified me with Mr. Biggs, even if for some reason he's gone over to the dark side on this one. Borrowing from his former principles, I proposed an amendment to the Midnight Rules Relief Act. Using language taken directly from his legislation, I proposed that any resolution we consider overturning agency rules should be limited to a single subject. And if the resolution tries to nullify regulations in two or more diverse subject areas, the resolution, as he would have it, becomes null and void. The whole point of the One Bill, One Subject House Republican movement, as I understood it, is that we should not avoid legislative transparency or accountability by shoving unrelated, mysterious packages into a single moving legislative vehicle. I'm going to insist on the same standard today. Congress can already block midnight rules one at a time with a scalpel. It seems deceptive backsliding now to smash all of them at once with the jackhammer. I urge my colleagues to oppose the Midnight Rules Relief Act, and failing that, I urge you to make my amendment in order, and I look forward to your questions, and yield back, Mr. Chairman.
Thank you very much. Appreciate you yielding back. Now recognize Ms. Fishbach for her questions.
Thank you very much. And I just want to refocus just a smidge. And this bill simply allows Congress to oversee the administrative rulemaking without bogging us down for each and every rule. But it is only on those rules that are issued in the last 60 days of a presidency. Is that correct, Mr. Klein?
It would allow for those rules that were issued in the last year
Okay.
of a president's term, but the CRA only allows for consideration within the 60-day window.
Okay. But it is limited.
Yes.
It is not this great, horrible thing that the opposition is trying to make it out to be, that we are just going to pile things together and create this bill, and it's great mystery to the entire country of what's in the bill.
No, I appreciate the question. It definitely would not. It is simply a measure designed to increase efficiency. The minority always has the option of bringing legislation to address the specific regulation that they're concerned about, and it would disincentivize what we saw out of the last administration, which was waiting until the end of the administration to issue over 1,000 regulations that really place an enormous cost on businesses, on citizens of the country. And so this is designed to address that, but also to assist in the efficient use of time by Congress and by the good gentlemen and gentleladies on this panel.
And Mr. Klein, I'll just mention that, last week we had a bill in regarding fentanyl. And there was a lot of discussion from the other side regarding executive overreach. And they were very concerned about it then. But now with this bill, where it would put some check on executive overreach, that doesn't seem to be the issue. And so I think that overregulation is something that we heard about all the time during the election. And we hear it still. We hear about it before the election, during the election, and after the election, about the overregulation, what it's doing to small businesses, what it's doing to our farmers. And so I appreciate that you are trying to get at that and be able to address it and rein in that executive overreach. And isn't it interesting that we had the bill last year, but we're continuing it because executive overreach is always there. So, we are consistent in the fact that we are looking at this and making sure that we can address the overregulation. So I appreciate you bringing the bill forward, and I yield back.
Gentlelady yields back now. Recognize Ranking Member McGovern.
Yeah, thank you. I'm a little confused. The gentlelady talked about us complaining about executive overreach and fentanyl. I don't recall that. All I recall during that debate was that some of us wanted to know why my Republican friends were okay with the President of the United States pardoning a guy who helped funnel fentanyl into this country, who was given a life sentence by a federal court. Why that was okay for him to be pardoned? So I don't know what I mean. The President has the right to pardon whoever he wants to pardon, but. The issue was, like, I was just surprised that so many of my friends thought that was okay, or, felt that was something they had to be silent on. And again, talking about executive overreach at this moment in time, is laughable, to be honest with you. These regulations, whether you like them or not, went through an exhaustive and legal process. And look what's happening now. This president and weirdo Elon Musk and his minions are going through people's personal information. They are trying to shut down USAID, and now we're told the Department of Education, they don't have the legal authority to do that. That's executive overreach. And the courts are ruling that it is executive overreach, and the president has no right to be able to do that. And now we're being told by the White House that they may ignore what the courts say. Now we have a constitutional crisis on our hands. And my friends are totally fine with all this just going on because it's Donald Trump and Elon Musk, and they're afraid to make any waves. But going to Mr. Raskin's point, under this bill, you can just put a whole bunch of these regulations into one package and have an hour debate, half an hour on each side. You may hide some good things in there that some people on your side might even think is a good, proper oversight of the federal government, and there'll be no debate on any of this. And when the gentlelady talks about us being, we don't want to be bogged down, I don't know. I'm looking at the schedule. Does anybody here think that we have a busy legislative schedule? I think we have 2 bills this week, plus some suspension bills. You could bring up 5 of these CRAs if you wanted to, and we have plenty of time to, do it. So it's a 5-minute vote, an hour debate on each one of them. The idea that we're bogged down, we're trying to save time. Come on, this is like, what are we doing here? I don't know, Mr. Raskin, do you want to add anything before I?
I would go further than that. I would say, if we had to stay past 5 p.m. or 6 p.m. in order to do the people's business, we should do it. And I mean it very seriously about Representative Biggs. I always appreciated the fact that he concentrated on voting on one discrete subject at a time so the public could understand what we're really voting on, up or down. And now suddenly, his name at least, I was hoping to see him here so I could ask him about it, but his name is on top of a bill that would allow us to pack in completely unrelated subjects on totally different regulations and vote for them en masse. When I count 66, that's a conservative estimate. That's just from the final 60 days. If we indeed took, as the good gentleman suggests, all of the regulations from the year. You could put hundreds in there and just vote them down. And I concede your implicit point, Mr. McGovern, that, well, at least they'd be coming to Congress to do it. With Elon Musk, he's just remaking the law on his own. He's a fourth branch of government. He does whatever he wants. So here, maybe they think that at least they would be gesturing at some form of legality. But I think that that's a really dangerous way to go, to have people voting on everything from, animal welfare to water quality to air quality to food and drug to the Defense Department to NSA to space, all in one bill. And how are you going to explain to people who are your constituents what you're voting on and what you did? Will anybody even be able to remember it? So that totally cuts against what I thought the Freedom Caucus has been fighting for, which is one subject, one bill, the name of their centerpiece legislation.
Yeah, I think the deal here is to not be held accountable. I mean, to vote on monstrosity pieces of legislation so that nobody can be held accountable for individual votes. And by the way, CRAs, as I remember, were all brought to the floor under closed rules. So, I mean, I assume that, you would bring this to the floor under a closed rule. You take away our ability to be able to amend things, to be able to offer amendments, and now you want to take away our ability to debate these subject matters. I mean, I think that's, that's dangerous for this institution. I thank you both for being here. I yield back.
I would note that Freedom Caucus is open to all kinds of folks, and if the gentleman wishes to join, feel free to fill out an application. That being said, Mr. Langworthy, for your time.
Thank you very much, Mr. Chairman. Representative Klein, to just clarify this, the process outlined under the CRA has been abused by both Democrat and Republican administrations through midnight rulemaking. Would that be correct?
Yes, although the costs imposed on businesses were made much worse by Democrat administration regulations.
Okay, thank you. And I understand our colleagues across the aisle have characterized this legislation as protecting the scammers at the expense of the American people. What would you say to this charge, and what sort of beneficial economic impact will this legislation truly have for American workers and American job creators?
Well, let's just look at the last administration's effort to pass several different regulations as they left office. You saw an impact on hardworking men and women who are maybe struggling to make ends meet, but trying to afford the basic necessities of life. A new Biden energy final rule issued in December of last year effectively bans gas-powered water heaters in homes by increasing their price by several $100s. Another Biden energy regulation issued in December forces appliance manufacturers to comply with onerous rules that slow down the washing time for dishwashers from an hour to less to more than 2 hours. Last October, the EPA issued a final rule that dramatically raised the cost of repairing commercial and residential air conditioning units. So you have several examples where hardworking men and women struggling to make ends meet, struggling to put food on the table, afford a dishwasher, afford an air conditioner, afford a gas-powered water heater, are going to find those products out of reach because of these regulations imposed by the Biden administration. And so it is important that Congress be able to respond, that this Congress be able to respond quickly and make sure that we stand up for the hardworking men and women of this country who we are elected to represent, and stand up against the onerous bureaucratic, bureaucratic regulations put forward by the last administration. So,
well, thank you very much, Representative Klein. Look, I think that the real scam here was the Biden administration shoving through more than $1 trillion worth of rules and regulations in the very final days, hoping and praying that the American people weren't paying attention and didn't see what they were doing. But for 4 years, the American people were paying attention, and they spoke in November, and they made a real course correction and change. This legislation will allow House Republicans to surgically pursue and eliminate the last-ditch efforts of a failed administration to oppose its left-wing agenda on the American people in a permanent fashion. I look forward to supporting this bill on the House floor, and I hope anyone who claims to care about transparency will do the same. And with that, I yield back.
Gentleman yields back. Now recognize Ms. Scanlon for her time asking questions.
Thank you. This is not the first time we've seen H.R. 77, the Midnight Rules Relief Act. It's been a go-to Republican messaging bill for, I think, 15 years. And that whole time, Republicans have never been able to pass it into law because it's bad policy and lazy legislating. Congress already has multiple procedures by which it can block or undo regulatory action. Congress can pass laws with more specificity. Congress can participate in the rulemaking process or rescind specific regulations using the Congressional Review Act. It's worth noting that this bill is specifically mentioned in Project 2025 on page 50 in a chapter authored by the new director of OMB, Russ Vought, who likes it because it would make it easier to dismantle our existing regulatory framework in order to replace it with the deeply unpopular Project 2025 right-wing policies. But the hypocrisy here is striking. You can't say this law is necessary to prevent executive overreach when at this very moment the Trump administration is engaged in the most egregious, illegal, and unconstitutional overreach in our nation's history. Congress, with both houses under the control of the Republican Party, is doing nothing, while Elon Musk and his merry band of whatever they are and other Trump appointees are rummaging through Americans' private information and national security secrets, shuttering agencies that Congress has established and funded to serve the American people, and firing federal workers, particularly the watchdogs, in violation of federal law. You know, Trump can't legally withhold congressionally appropriated funds, and Elon Musk, an unelected private individual with huge conflicts of interest, cannot cut or redirect how congressionally appropriated funds are spent. You can't have it both ways, claiming to need more tools to overturn regulations and laws implemented by a Democratic administration, but being unwilling to confront blatantly illegal conduct just because it's Trump and the Project 2025 gang. Don't you think Congress maybe should be focusing its energies on bipartisan bills that actually help, say, lower costs for the American people or have a chance at becoming law? Or maybe Congress should be focused on doing its main responsibility, appropriations, a budget for the 2025 fiscal year, which started months ago. Republicans should come to the negotiating table to get a deal on government funding before the government runs out of money in mid-March, and working together to reassert Congress's core Article I authorities. For all their talk about the Constitution, congressional Republicans have abdicated Congress's core constitutional responsibility for lawmaking, for appropriations, and seem happy to sit by while Musk and gang shut down core parts of the federal government. So there's no way around it. Because their guy is in the White House, Republicans don't seem to have a problem with executive overreach and seem to be willingly relinquishing Congress's status as a co-equal branch of government. So, you know, we've talked many times in the past, both at the Judiciary Committee and in this body, about why this is bad policy and a bad bill. And when there's so many other important things on the table right now, it seems like a real waste of Congress's time to be running through this one again. Mr. Raskin, did you have something you wanted to add?
Well, thank you, Ms. Gillen. I mean, it is a terrible waste of time, obviously, but let's take it on its own terms, okay? Here are the rules that were passed in the last several months of the last administration, okay? Removing lead from drinking water, making cell phones compatible with hearing aids for older people, creating safety standards for infant bath seats, implementing the National Suicide Prevention Hotline, and prohibition of sale of tobacco products to persons under 21. Okay, so let's say you thought all of that was a great idea, but you really think that people under 21 should be able to buy tobacco products. So you want to vote to overturn that one, but you want to vote to uphold all of these other ones. You would have to choose. You would have to violate your conscience or your belief in one case or another. Say you wanted to really get lead out of drinking water, but you also wanted to allow 19-year-olds to smoke. What would you do? You see, I thought that was the Freedom Caucus's whole point. And Chairman Griffith, I accept your invitation to come to the Freedom Caucus. I would love nothing more than to come and to debate this and to talk about this issue. If it was meant sincerely.
Well, it wasn't an invitation to come, it was an invitation to join, since you now see the wisdom of the Freedom Caucus.
Well, I've discerned the wisdom of the Freedom Caucus in many cases, and I don't get to check it out once before I join. Can I come for one meeting and have a discussion about this and then make my decision? But in any event, look, regardless of whether you consider yourself right, left, center, libertarian, authoritarian, whatever you are, you could be on the Steve Bannon side of the Republican Party and think that Elon Musk is a truly evil individual, as he said, or you could be on the Elon Musk side and you believe in a techno state replacing America's Constitution. Whatever side you're on, this is very poor legislation. Is the opposite of what the Freedom Caucus has been fighting for. It's the opposite of what any of us should want. We should vote on one subject at a time, and I come from a state that takes that very seriously, which is why I was drawn to what I thought, the original position was of the author of this legislation.
Thank you. And I do think it is worth looking at some of the regulations at risk here. I mean, the one about allowing consumers to unsubscribe from a service as easily as they can subscribe to it. That's one of the recent regulations, which is wildly popular, particularly in my household.
Our constituents should know how we're voting on that.
Right.
And not say, oh, well, I had to vote against that because I wanted to vote against some other completely unrelated bill.
Well, I'm sorry Mr. Roy and Mr. Massey aren't here, because I know they're huge advocates for what you were just speaking of, and just having single subject bills to address. So thank you for your input, and I yield back.
Gentlelady yields back. Now recognize Mr. Scott for his time for questions.
Mr. Chairman, I don't have a whole lot of questions. I'll just tell you this. The American citizens are sick and tired of unelected bureaucrats in Washington, D.C. telling them how to live their lives. And any of these major rules should have to come back before the Committee of Jurisdiction, where they could be approved or rejected by the people's elected representatives. I plan to vote for the bill, and with that, I yield the remainder of my time.
I thank the gentleman. Now recognize Mr. DeGoose for his time to question.
I thank the chairman. Thank you to the ranking member, Mr. Klein, both of you for being here and for testifying on this bill. Most of my questions are going to be for you, Mr. Klein, whom I consider a friend, but of course, as you can probably gather, on opposite sides of this particular piece of legislation. I'm trying to understand the urgency behind this particular bill. I mean, you've articulated that it's important. Clearly, you all have prioritized it in terms of getting this done early in the Congress. Why is this such an urgent matter?
Well, part of it is in response to the over 1,000 regulations that were issued by the outgoing administration within the final months of the administration.
Got it. Okay. So I guess, given that, here's my question. We've been in Congress, we've been in session in 2025 for 37 days. Sound about right? Sworn into Congress on January 3rd? Right. How many disapproval resolutions have Republicans brought to the floor of the House so far?
I think that there are several in the pipeline, but I don't know of any.
The answer is 0. House Republicans have brought none. You mentioned there are 1,000 regulations that the Biden administration promulgated last year. You're really concerned about them, as are my colleagues on the House. You've endeavored to put not a single disapproval resolution on the floor in the first 37 days. Do you know how many have been considered by committee?
I would love to be majority leader and put them on the floor.
Well, I can tell you, with respect to that particular question, it's an easy answer, 0.
But
no committee has considered a single disapproval resolution of a single rule. The House, as a body, has not considered a single disapproval resolution thus far in the 119th Congress. Apparently, this is a top priority of House Republicans. You are here to ask members to approve a bill that would allow us to disapprove of rules en masse, omnibus fashion, thousands of pages to be considered in a single vote, and yet House Republicans can't find their way to putting a single disapproval resolution on the floor? I don't understand it. You care to indulge me?
I would say that there are several that have been introduced and that are moving through the process.
Why not do one? Why not put one on the floor before you bring this bill? Why not try the current system? I mean, apparently, I thought the argument here was that There's so many different rules that you all are so eager to disapprove of, and you don't have time to be able to disapprove of all of them during the pendency of the 119th Congress. So you want to change the rules so that you consider them on an omnibus or in an omnibus way. I don't get it. But anyway, I think I've probably belabored the point on that front. You made reference to a variety of the different rules that you disagree with, and I thought that my colleague from Pennsylvania and the ranking member of the Judiciary Committee articulated, in my view, the reasons why so many of those rules ultimately inure to the benefit of American families and American businesses. Of course, I'm sure you're familiar with the CFPB's overdraft rule. Are you familiar with that?
I am.
Yep. So this is a rule that the CFPB promulgated, published after open comment, to limit overdraft fees for consumers, correct?
That's my understanding.
Right. And by most empirical accounts, it will save Americans $5 billion, over $200 for every American household every year in overdraft fees. Working families who ultimately would have money in their pocket by virtue of this rule that was issued by the CFPB. And this is the type of rule that you seek to disapprove of on an omnibus basis, right?
I would take issue with that. I think that we would be selective in which regulations we were seeking to.
Do you agree with this rule?
I don't have a position on the rule that you mentioned, but the three that I mentioned before would easily be taken up by the Committee of Jurisdiction, which is the same committee, the same issue, all dealing with appliance regulations, and could be put out. And you're not dealing with multiple different areas of jurisdiction. You're dealing with three regulations that would help to reject them would help consumers.
Now, one question, I guess, Mr. Klein, maybe this is a bit esoteric. I presume that you believe passionately in the CRA and the disapproval mechanism because it enables Congress to weigh in on a particular rule, and ultimately, if that resolution is successful, to end enforcement or implementation of that rule. Is that a fair assessment of your position?
It is.
Okay. So what happens when an agency just decides, sua sponte, to not enforce or implement any rule whatsoever? Why is the disapproval resolution necessary?
Well, it would depend on the agency, the regulation, and
Let me give you a real-world example. The CFPB has 2,000 employees, right? The Trump administration just directed all employees to stop work. They issued an order, quote, not perform any work tasks this week. They have in effect shut down the CFPB. They have shuttered the headquarters. None of the rules that the CFPB promulgated last year are presumably being enforced right now because the agency has decided, or the administration has decided, unlawfully I might add, and I believe ultimately will be vindicated in the courts, to, on their own, unilaterally say that the agency is done doing any work. I mean, do you understand why this seems like a bit of the twilight zone to me, that we're debating Congress's ability to disapprove rules when the Trump administration is shuttering agencies without any input from Congress?
well, my understanding is that Administrator Vaught has instructed employees to work from home and that for the week they are paused during that time. But what
do you mean by paused?
I am quoting the administrator. But
No, but I'm trying to understand what paused means. What do you mean?
as you said, not performing any of their tasks.
Got it. So 2,000 employees who are being paid have just been told to stop all work. Don't come in the office. Don't send any emails. Don't make any phone calls. This is your effort at unrooting government fraud and waste and abuse, to have thousands of employees who are directed to do nothing but receive a paycheck? Explain this to me or to the American people.
This is the result of years of Democratic congressional leadership mismanaging the authority of the executive branch and essentially giving away Congress's authority to legislate to the executive branch, to essentially, through promulgation of regulations, run the government. And so what this institution is seeking to do is to regain its authority to legislate and to actually, for lack of a better term, make Article 1 great again.
Mr. Klein, this resolution would in effect be a dead letter. The Trump administration is taking your authority.
Because you gave it away.
Okay, so it's Democrats' fault that Republicans have decided in the Trump administration to unilaterally
Cede
tell
power to the
workers
executive
within these
branch.
federal agencies to cease all work. I might just say, because I have great respect for you, Mr. Klein,
Feelings being shared.
the precedents that are being set right now are deeply dangerous. Deeply dangerous. And I worry that my colleagues on the other side of the aisle, I don't know if it is from a failure of lack of imagination to kind of understand the consequences of these steps that you're taking. If the President of the United States, via their OMB director, can effectively tell agencies and any employee in our federal government to cease all work on a whim, that's the new standard? That's really what you're comfortable with a future president, a Democratic president, retaining that authority and saying, yeah, it's up to me. Through my OMB director, I can have them send an email. It doesn't matter if it's 100 employees or 100,000 employees. I can shut down every single piece of work that they are doing, whether or not it's been authorized by the Article 1 branch. That's your position?
We want Congress to be able to speak to the regulations being issued by the executive branch, regardless of who's in charge.
Well, this is a far cry from that, in my humble view. I would, ranking member, if he would like to expound on that, I don't know if he...
Mr. Neguse, thank you for those trenchant observations. It's also significant that you raised the overdraft regulation, because I've not heard our colleagues be willing to criticize a single one of the rules that would be thrown in, other than Mr. Klein's suggestion of the three which were all in one committee. I'm wondering, one, is he suggesting that this legislation be narrowed to do it subject matter by committee, that they could be bunched by committee, which would be obviously a vast improvement. It's unnecessary, but it'd be a vast improvement over this, terrible potpourri conglomeration of bringing regulations in from different places. But the CFPB, which is now under attack, which has essentially been shut down de facto by Elon Musk, saves Americans $15 billion a year. It got consumers $17.5 billion back since 2011. So they're shutting down the agencies that help the American people. The EPA gives us clean air and clean water. The NLRB and the Labor Department, which have been targeted, are defending the right to organize into a union and to collectively bargain. The Consumer Financial Protection Bureau protects all of us against rip-off practices by banks and so on. And it's not enough for Elon Musk to arrogate to himself the unilateral power which belongs to Congress and shut down agencies that we've created and that we've appropriated funds for. That's not enough. Our colleagues here have to say, and we want to make it easier for us to overturn all of the rules that have been adopted in the last administration, and we don't want anybody to know specifically what we're voting on, so we'll throw them into one huge stew pot so nobody knows. And then, if I were voting to overturn a regulation removing lead from drinking water, or if I were voting to strip a regulation which creates safety standards for infant seats in bathtubs, I wouldn't want anybody to know about it either. I would try to hide it and lose it in a crowd of other regulations. But I think that's a disgraceful way for us to legislate, and it's something which I thought that liberals and conservatives, right and left, agreed upon. We should vote on one thing at a time.
I couldn't agree more. I want to yield a moment to the gentlewoman from Pennsylvania.
Well, if I would remind folks, we're trying to adhere to 5 minutes as best we can, and we're already at almost 12.
Mr. Chair, I just want to say that some of us use a fraction of our time, and there's 4 of us and 9 of you. So I appreciate that.
And so it is.
I just had one quick question for Mr. Raskin. I know our friend has said that this law is necessary for Congress to reclaim its authority with respect to lawmaking, et cetera. But couldn't Congress right now pass laws that would reclaim that authority, which could overturn regulations that are not agreed to, that, or narrow the rulemaking authority that had been given to the executive?
Yeah, obviously, I mean, the claim that Congress needs to do that to reclaim our authority is an irrelevant rhetorical distraction, because we already have that authority with respect to specific regulations. And of course, we can legislate whenever we want. I mean, our friends control the House, the Senate, and the White House. If they want to overturn a safe drinking water regulation, they can just go ahead and do it. Or if they want to use the CRA, they can do it one at a time. But this is an effort basically to say, all right, everybody, let's suck it up, hold our breath, and jump into the deep end of the pool together, because we're going to overturn all of these regulations that the public wants and depends on at once.
And if Congress similarly doesn't think there are enough regulations in certain areas, such as who can go trolling through Americans' data in the Treasury Department or the Labor Department or anywhere else, if it says you have to, if Congress thought it was necessary to keep Mr. Musk and his crew out of people's private data and out of his competitors' data, Congress could pass that law if the Republicans agreed, right?
Congress should pass that law, and in fact, one regulation that would be overturned conceivably in this omnibus monstrous package is called Preventing Access to U.S.-Sensitive Personal Data and Government-Related Data by Countries of Concern. So if we're afraid that our private data could be leaked out, including to foreign countries, that's something that's actually covered by one of the rules that could be targeted by this approach.
I appreciate that. I yield back to Mr. Neguse.
And I yield back to Mouse.
Gentleman yields back, now recognize Mr. Jack for his time.
Well, thank you very much, Mr. Chairman. If I can ask my distinguished colleague from Virginia, Mr. Klein, just a question to help me better understand this piece of legislation. So, and Ms. Fischbach talked about the time limits earlier, but just so I understand, at present, the Congressional Review Act enables us to have 60 days from the publishing of a rule to potentially disapprove of it as a body. And H.R. 77, does it allow us to consider something within the last year? Is it 365 days, or is it any time period?
I thank the gentleman for his question. If those regulations are issued within the last year of an administration, they can be acted on under the current 60-day requirement under the CRA.
Got it. And if I can ask, just ballpark, how many regulations does an administration publish in a calendar year?
Oh,
Hundreds, thousands?
tens of thousands.
Tens of thousands.
I would think.
So, in effect, this bill, just to help me understand, it would make it more efficient for us to address those tens of thousands of regulations, and it would frankly empower the committee chairs and the committee members, the members of our body, to rectify some of these challenges at the committee level, and then it rises up into one package for us to act on efficiently on the floor. Is that right?
Yes, nothing in this legislation would restrict currently the ability of committees of jurisdiction to bundle together these types of disapproval resolutions for consideration. So the Judiciary Committee could bundle together resolutions related to the last administration's open border policies, the treatment, the misinterpretation of asylum law, any number of issues under the Judiciary Committee's immigration jurisdiction. So,
Well, I appreciate that, because I do want to spend a little bit of time today just to highlight one specific rule that I care a lot about that directly impacts my district. And I have to imagine every single one of my colleagues has a rule or some type of hindrance that's been imposed upon your constituents that you may want to see acted on en masse as well. For me, in my congressional district, Georgia's 3rd Congressional District, the Department of Energy published a rule, you can see it, 89 Fed Reg 105,188, that effectively will put out of business highly efficient tankless water heaters, which are manufactured in my district. I've got a plant within my district that employs 550 constituents that's going to go out of business if this rule goes into effect. And it's set to go into effect March 11th. I'll be pursuing any legislative vehicle I can to address it, because ultimately I got 550 constituents that are going to lose their jobs if this thing goes through. You mentioned this today. But I just want to note that every single member of our distinguished House probably has an example of this, and I'm hoping to get consideration of this on the floor, but I certainly respect the effort of this piece of legislation to enable me to have multiple options, multiple windows, and multiple avenues to address this, because at the end of the day, I got 550 constituents that are hoping to keep their jobs. They're not going to have it at this rule that was published, a very different edition of a midnight rule was published on December 26th, the day after Christmas. I've got to address it to help my constituents, and I appreciate you bringing this legislation to the floor. Welcome any closing comments from you on that before I yield back.
I appreciate the gentleman's comments. It's exactly what we're trying to enable Congress to enact on behalf of the American people, to ensure that Congress makes the laws and not unelected bureaucrats working without any accountability and hindering the ability of working men and women to either get jobs or work in a facility like the one that's in your district. Thank you.
Thank you very much. I yield back to our chairman.
Gentleman yields back. Now recognize Mr. Norman for any questions he may wish to ask.
Thank you, Mr. Chairman. Just for the record, I noticed my good friend on the opposite aisle mentioned some people or was criticizing President Trump's giving pardons to. Let me just name, I've got a whole, I don't know how many, 30, but let me just tell you the little angels that our past president pardoned. Richard Tempton, sentenced in 1993 in Virginia, death in participation of a drug-related killing. Third co-defendant, Corey Johnson, was put to death on January 14th in the final days. Another little angel, Julius Omar Robinson, sentenced in 2002 in Texas, death of killing 2 men in a drug-related episode. Another little angel, Ricardo Sanchez, sentenced in Florida for the death of a killing of a family, including 2 children.
Will the gentleman yield just for clarification?
I will in just
Are these
a minute.
pardons or a commutation of death sentences?
I think these are pardons.
No, I did
These
not.
pardons are commutations. Anyway, let me just,
Okay.
it'll
Facts.
give you the flavor. Daniel Troya, sentenced to death of a drug-related, well, that was the one with the children. I mean, I could go on, I didn't get into the drug-related, but you brought up
They're still in jail.
Mr. Trump.
And Mr. Trump
and
pardoned
his
the guy who was
nominees.
sentenced to life in prison. He's free. These guys are still in jail.
I reclaim my time. Look at the record, but you can go into the pardons that this ex-president did. I'll also say that, y'all keep mentioning the fact that we are having investigations. Elon Musk is doing this free of charge. I forget what you said you referred to him as an imbecile or something. I think he's made it in the private sector pretty well. And I think what he is uncovering, free of charge, the American people are shocked at. And I hope y'all continue to protest, because when American people find out where their tax dollars went, this is government gone awry. And the USAID is the first one. The CFPB needs to be abolished, and the things that were brought up about the fees, they're a competitive industry with other banks. Government shouldn't be telling them what fee to charge or not charge, because they have to compete. So I think it's interesting. That's off topic, but I wanted to bring that up. The commutations, whether it's
So, I'm
that or
sorry,
pardons,
you-
or whether it's, I'm reclaiming my time. I'll give you a chance.
Okay.
And the fact that continue to get on Elon Musk. The American people love what he's doing. 77 million people voted for President Trump to stop this kind of abuse that's going on in this country. And I think this is just one agency. Mr. Klein, I think ex-President Biden had 1,406 rules that are going to be subject to the look-back provision. And I'm, like Mr. Jack, we've got companies in my district, a dryer manufacturer, 800 people, very upset that gas, that they're taking gas away from being able to manufacture. This is a competitive industry. not government-run. And can you hit on a few more ludicrous things that occurred during the time frame that will require a look back? Because I remember the gas, outlawing gas, ovens. I didn't know about the water units that they were trying to abolish, but can you name just a few more that would give us an example of what this insanity that we considered?
And you hit the nail on the head when you said that these are businesses, American workers, American families being affected by these regulations. And they're not just in the energy sector, but those were where this Green New Deal administration focused its attention. And when you talk about single-purpose legislation, let's talk about that Inflation Reduction Act. Let's talk about all those provisions and how many different parts were in this mammoth trillion-dollar bill. But as I said, you have air conditioning units, you have dishwashers being overregulated, gas-powered water heaters being overregulated in the name of energy efficiency. But what you have is instead rising costs for American consumers and these items being placed out of reach for the American people.
Well, and the list can go on and on. I mean, as far as, I don't know whether it fit in the parameters that we're talking about for this legislation, but the insane student loan bailouts, the insane Green New scam with the $7,500 electric vehicles, government telling Americans what they need to buy for cars, it's insanity. Fees on asylum applicants, overstays. I mean, what the past administration has done is force these kind of actions for us to take that's going to help right the wrongs.
And I can give you one more, the tailpipe emissions rule, an effort to force Americans to abandon gas-powered cars for electric ones. Would make 50% of all new vehicles electric by 2030. The imposition of those costs on the American people.
Let me just say this too. I don't think my friends on the left understand businesses operate. When you have a rule that's coming down on them, they invest their hard-earned dollars in capital for equipment. It's not just a flip of the switch, a flippant. That's where you really needed to have been in the private sector to understand how it affects the everyday working man, which they will be the ultimate judge. When the jury's out, when the jury's decision's made and the jury is out, are they going to approve this one bill, USAID, and where that money went? Let's let them judge it. I think we rest our case on that. I yield back.
Thank you, Mr. Norman. Mr. Griffith, you're recognized.
Thank you very much, Madam Chair. Mr. Klein, my good friend and neighbor in Virginia, the way I hear your bill being described is not the way I read it. It sounds like all 1,406 regulations that are being tracked by the Judiciary Committee, if I'm listening to my colleagues on the other side, that if a bill were to be brought forward, your bill would require all 1,406 be in there at one time. That is not accurate, is it?
No, I'd say to the gentleman, it's not. It's allowing the committees of jurisdiction to select which regulations would be considered together that might have the same topic or cover the same issue.
And switching gears a little bit, I was a little surprised to hear such a mischaracterization of the single subject rule. And the gentleman has heard me pontificate on that rule since our days in the Virginia House of Delegates together, have you not?
Yes, I have.
And did we ever say that it was only one small issue at a time, or did we say the subjects had to be related?
That's exactly right.
The subjects had to be related. So that's why I've never objected to an appropriations bill. I've never objected to a reconciliation bill. I've never objected to a National Defense Authorization Act. Even though they're broad, the gentleman would agree with me, those are three areas where we consistently have very large, very broad bills, but they are a single subject. Would you not agree?
I would agree.
And so what this does is this does not get rid of the single subject at all. It merely says that we're taking up regulations that we find are inappropriately passed by the prior administration, and your bill would say that we can look at them. It still has to be within the 60 legislative days, but we can compile them together only during the last year of any administration. Is that accurate?
That is accurate.
And so then we could take them up, and if we desired to do them by committee, we could do that, but we're not mandated to do that by this bill, are we?
No.
Now, I'm going to go a little far afield here because some people were talking about how we like the CRA, and they asked you a leading question about the Congressional Review Act. I will tell you, and I don't know what your opinion is, I have always thought the Congressional Review Act did not go far enough in protecting legislative Article 1 prerogatives, because what it says is if an unelected bureaucracy enacts a regulation that Congress doesn't like, we can't withdraw that on a mere vote of the House and the Senate, a mere majority in the House and the Senate. We have to not only get the majority in the House and the Senate to undo a president's action or his executive branch action, we have to get the president to agree with us. So therefore, that limited time from the time of the inauguration of a new president, which eats up, before you get the old president out of here, we've already eaten up a bunch of the days in the 60 legislative days, and no president is going to say, I had my team enact a regulation that I'm now going to say we made a mistake. No president's going to do that on his way out the door. So the urgency is that we only have a limited amount of time to look at and make decisions on 1,406 pieces of legislation, and we don't even have the full 60 days because part of that 68 days was eaten up in the prior administration. Am I not correct?
You are correct, Madam Chair. I'd say that once that horse is out of the barn, you are not able to easily get it back in.
And so what we probably ought to be doing, if we really want, if my colleagues on the other side of the aisle want to join me in really giving us Article 1 power back, we will pass something that says any regulation that Congress rejects on a majority vote of the House and the Senate is automatically null and void without having to get a presidential signature. That being said, Madam Chair, I yield back.
Madam Chair, can I have a unanimous consent request? I'd like to ask unanimous consent to insert the bill that we're talking about into the record, because nowhere in this bill does it say anything about single subject or single committee. You can do whatever the heck you want to do under this bill. There's no limitations in this bill. Maybe, my friend, maybe we should read the bill before we make, Mr. Klein, you said.
Without objection, the chairman, the gentleman may insert the text of the bill.
Madam Chair, might I respond?
Yes,
I
sir.
was responding to the arguments of my colleagues on the other side. If it comes in and it appears there's not a single subject, now I would submit rolling back regulations is in fact, by definition, a single subject. But if the gentleman wants to bring that up, I would probably support something that truly made it a single subject. But the amendment that was previously offered does not do that because it says it has to be the same subject. And I will tell you, Madam Chair, the same subject is rolling back bad regulations within the last 60 days. That's a single subject. So I have no problem with that. But I was just responding to arguments by the other side and showing how their arguments made no sense to me. And I yield again.
Thank you very much, Mr. Griffith. Ms. Houchin, you're recognized.
Thank you, Madam Chair. Thanks to my colleague, Representative Klein, for being here. Also to the ranking member, Raskin. I have no questions. I yield back.
Thank you. You get the record for today. Mr. Roy, by the way, before I recognize Mr. Roy, I want to say how much I appreciate the arguments of Mr. Griffith, and I want to associate myself with your comments, because this is absolutely taking back our Article 1 authority, and I cannot understand why the Democrats constantly want to give that away. Mr. Roy, you recognize.
Per his request, I will yield a little bit of time to my friend from South Carolina who wanted to insert something.
Thank you, Mr. Roy. I just want to get back to my good friend, Mr. McGovern. The list, 39 were fully pardoned, crimes wiped from their records. The second list, which is even worse, he commuted their death row sentences. He commuted the death row sentences to life in prison.
They're still in jail.
I yield back.
Thank you, Mr. Roy.
I yield back to
Mr.
Roy.
So a lot of this has been covered, and I know we want to get to the vote. Just 2 or 3 points. I mean, to my friend from Virginia, and I think my other friend from Virginia, Mr. Griffith, covered this. But, I mean, again, for the American people at home watching this, like, what's at play? What we're talking about is when an administration carries out a lot of activities, right, through rulemaking and executive action. And they do that, and it could happen in both parties, but they do that, and often the waning days, the last year of administration, and they're out and they're making a lot of rulemaking. And the question then becomes, what can Congress do about it? And this bill, as I understand it, would do 2 primary things, right? Which is allow you to go back a year instead of 60 days into the last year of the administration, in which we saw in this administration considerable activity, specific, fairly sizable and significant policies, such as the student loan forgiveness program, which is tens of billions, hundreds of billions of dollars. Significant amount of activity carried out by administrative action, right? Not because Congress got together with the president and said, hey, we've had these student loans, and forget the fact that you've got plumbers and electricians who didn't take out said loans, or other people who are entrepreneurs, people who chose not to, or, for example, my wife, the daughter of a single mom who is still paying off her student loans for both undergraduate and law school at A&M and UT, in-state tuition, so hardly expensive, relatively speaking to some schools, and is still paying those off, and has been paying those for 20 years now. And the question becomes, is for people who've gone out and they've paid off their loans, now by executive action, by the mere stroke of a pen, and by action of bureaucrats assembling all of this, boom, that gets done. And then other activities which we could go into in great detail, and I won't, whether it's H-1B issues and labor, which might have some disagreements on both sides of the aisle, regulations involving firearms and other things. Lots of regulations, lots of things being done. And the question here is, can Congress exercise its Article 1 authority going back a year, and then can they aggregate some of these rules to disapprove in some aggregated fashion? Now, to the extent that there's some concern about aggregating wildly varied topics, I assume maybe we could potentially consider debating that notion. But it seems to me that what you're doing is, to Mr. Griffith's point, is you're saying there was regulatory activity by the executive branch that Congress, in its decision-making, would say, wait a minute, no, we think that those ought to be stopped. And that doesn't prohibit going back to the well, doesn't prohibit then legislative action to fix some problem that was then created. Do I understand that right from your perspective?
That's correct.
The only other point that I would make is when we talk about the supposed, horrible activities going on by Mr. Musk, again, I would point out that he's operating within an entity at the White House created by President Obama, that then he's got individuals working around him to look at information as we understand it, and some of the back and forth going on with the courts right now that we will see as we see unfolding in the back and forth, and then I guess now going to the Supreme Court and whatever they're going to do, that we've got, their perspective is over-the-shoulder authority, look at stuff, okay, fine, we'll see, but the understanding is what are the results? I think our colleagues on the other side of the aisle are frustrated because of some of the things that have been exposed. And you can say, well, it doesn't add up to that much. Well, not maybe, first of all, it does add up to a lot. For the average American, these things add up. But we're talking about things that when you start getting into, for example, Social Security numbers that we now know are not deduped, and that there's a significant amount of duplication of Social Security numbers. There might be some good reasons why there's still some in the system. There might be others where you don't understand why. It might have something to do with non-citizens who are using Social Security numbers. But whatever, there's significant amount of duplication that they're now rooting through. I think the vast majority of the American people are looking at their government saying, well, it's kind of nice to have somebody with fresh eyes going through this with algorithms, trying to root out a lot of the things that we in Congress have been saying we wanted to try to get access to for years, from frankly both parties in power in the executive branch. But even with just the USAID, right? $2 million for sex changes and LGBT activism in Guatemala. Now, let me assume that for some reason you think that's an extraordinarily good policy. I don't. Should we be giving $2 million to Guatemala for said activity? Or $6 million to fund tourism in Egypt? I mean, Egypt seems like, a place that attracts lots of people to go there for history and look at the pyramids. We got to give $6 million while we're racking up $2 trillion in deficit spending every year in tourism to Egypt, or the millions that went to the Eco Health Alliance, which is neck deep in all of the research at the Wuhan lab, or how about the $32,000 for a transgender comic book in Peru? But again, if you think that's the most important issue in the world, I disagree. I think it's a problem. But a comic book in Peru, say, well, it's just $32,000. Well, how many just $32,000 are there? How many just $2 million are there? $70,000 for a production of a DEI musical in Ireland. Okay, it's just $70,000, just one person's salary. $1.5 million to advance diversity in Serbia. Hundreds of thousands. I keep going on down the list. The point is, finding a way to expose that which most of us see with our own eyes. And I would assume my colleagues on the other side of the aisle, there are going to be things that are funded that won't bother me as much by some executive action, but it should bother all of us that was funded, that we didn't stipulate that. And at some point, that's something we ought to reclaim. And look, I'll listen to the concept about whether there's something that's too aggressive in aggregating all of these. But right now, my response to that would be, we've given so much power to the bureaucrat and the executive branch that just do this, that I'm not that bothered by the chance that Congress would come together, aggregate these, and then come together on as Congress and say, we're going to pull those back. So anyway, for those reasons, I support the legislation. I yield back to the chair.
Thank you very much, Mr. Roy. I want to thank our witnesses for being here today. The witnesses are now excused. The chair will be in receipt of a motion from the gentleman from Virginia, Mr. Griffith.
Oh, okay,
I'm sorry. From Ms. Fishback. Sorry.
That's all right. Madam Chair, I move the committee grant H.R. 77, the Midnight Rules Relief Act, a closed rule. The rule waives all points of orders against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of orders against provisions in the bill. The rule provides 1 hour of general debate, equally divided and controlled by the chair, ranking minority member of the Committee on Judiciary, or their respective designees. Finally, the rule provides 1 motion to recommit.
Thank you very much. You've now heard the motion from Ms. Fishbach. Is there any discussion or amendment to the rule?
Yeah,
Mr. McGovern?
Madam Chair, just a couple of things. I mean, again, this is a closed rule. I mean, my friends are trying to take our ability away to offer amendments, and if this bill passes, you'll be succeeding in taking our ability away to debate a variety of issues. And I appreciate the selective accounting by the gentleman from Texas when it comes to USAID. It's funny that no one seems to be outraged on that side over an emergency $49,000 paint job for the Secretary of Defense. I could bring him to Home Depot. I could get it cheaper at Home Depot than what they're paying. We'll have a lot more to say on that. But Madam Chairwoman, I have an amendment to the rule. I move the committee make an order. Amendment number 1 to H.R. 77, offered by Representative Raskin, which prohibits any resolution of disapproval from addressing 2 or more unrelated subjects. Madam Chairwoman, we heard persistently from some of our Republican friends about the importance of having bills that address a single subject. You all could not stop talking about how bills with unrelated matters are the antithesis of good legislating. And yet, here we are today with this bill that would allow you to include in a single bill any and all unrelated regulations you choose, no matter what committee they may be under the jurisdiction of. Well, this amendment will prevent that. So you can either vote for this amendment to dispel any question on your hypocrisy, or you can vote against it and affirm your hypocritical position on legislating. And I urge a yes vote on my amendment, and I yield back the balance of my time.
Thank you, Mr. McGovern. Thanks for characterizing what kind of people we are. Is there any further discussion on the amendment? Hearing none, the question is on the amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no? No. In the opinion, Chair, the noes have it.
We'd like a roll call on that, Madam Chair.
Mr. McGovern requests a roll call. The clerk will call the roll.
Mrs. Fishbach? No. Mrs. Fishbach, no. Mr. Norman? No. Mr. Norman, no. Mr. Roy? No. Mr. Roy, no. Mrs. Houchin? No. Mrs. Houchin, no. Mr. Langworthy? No. Mr. Langworthy, no. Mr. Scott? No. Mr. Scott, no. Mr. Griffith? No. Mr. Griffith, no. Mr. Jack?
No.
Mr. Jack, no. Mr. McGovern?
Aye.
Mr. McGovern, aye. Ms. Scanlon? Aye. Ms. Scanlon, aye. Mr. Neguse? Ms. Ledger Fernandez? Madam Chair?
No.
Madam Chair, no.
The clerk will report the totals.
2 yeas, 9 nays.
Through? You done? Okay, the amendment is not agreed to. Are there any further amendments? Okay. Then, hearing no further discussion, the question is on the motion from the gentlewoman from Minnesota. All those in favor signify by saying aye. Aye. Those opposed, say no.
No.
In the opinion of the chair, the ayes have it. The motion is
For a roll
agreed
call,
to.
Madam Chair?
Mr. McGovern requests a roll call vote. The clerk will call the roll.
Mrs. Fishbach? Aye. Mrs. Fishbach, aye. Mr. Norman? Aye. Mr. Norman, aye. Mr. Roy? Aye. Mr. Roy, aye. Mrs. Houchin? Aye. Mrs. Houchin, aye. Mr. Langworthy? Aye. Mr. Langworthy, aye. Mr. Scott? Aye. Mr. Scott, aye. Mr. Griffith? Aye. Mr. Griffith, aye. Mr. Jack?
Aye.
Mr. Jack, aye. Mr. McGovern?
No.
Mr. McGovern, no. Ms. Scanlon? No. Ms. Scanlon, no. Mr. Neguse? Ms. Ledger Fernandez? Madam Chair?
Aye.
Madam Chair, aye.
The clerk will report the total.
9 yeas, 2 nays.
And the ayes have it. The motion to report is agreed to. Accordingly, Ms. Fishbach will be managing this amendment for the majority.
And I will do it for the minority.
And Mr. McGovern will do it for the minority. Without objection, the committee is adjourned.